Good afternoon and welcome back to the Public Service Commission as we continue in the hearings in docket numbers 2023-38-E and 2023-39-E. I should say as we continue in oral arguments in those dockets. Let's take a roll call of commissioners present in the hearing room. We have Commissioner Justin Williams, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. With us virtually we have Commissioner Irvin. Mr. Snowden, you're still in the batter's box, and Commissioner Carolee Williams has a question.
Okay. Thank you. Actually, Chair Belser and Commissioner Williams, if I may, just before we get started, I was informed by somebody much smarter than me over the break that I had given a factually incorrect answer to one of Commissioner Williams' questions. This question about whether you could just add an indefinite number of panels to a solar facility and keep that same 75 megawatt output at the inverters. That is not right. You cannot just go hog wild with panels. There are engineering limits, which I am not smart enough to talk about. I think the witnesses probably can do a much better job. But my understanding is that the actual engineering constraint is somewhere around that 1.3 inverter loading ratio that is observed. So that's all I have to say.
Thank you for the clarification, Mr. Snowden. You're not under oath, so we will allow you to.
I appreciate. I answered it to the best of my ability.
Speak with someone during the break, and appreciate the clarification. But
I am not testifying. I understand that. The best of my ability is sometimes modest.
Commissioner Carolee Williams.
Thank you, Chair Belser. Good afternoon, Mr. Snowden.
Good afternoon.
I have two questions. One is you talked some about the ability for zoning ordinances in counties to, reflect the desire of those entities, those counties. Somewhat of a curiosity question, but do you have knowledge of, and can you share some with me about like the number of counties that have specific zoning ordinances related to solar?
I do not. I am not a land use lawyer and don't hold myself out as one. We would be happy to provide that information if that'd be helpful, but I don't know.
And then my other question has to do with several elements in your brief that talk about the Commission's longstanding policy with regard to the Siting Act. And are there examples of dockets that reflect that longstanding practice, or is it the absence of any applications that suggest that practice?
That is a great question. I think it is a little bit of both. Primarily, it is the absence of applications for projects that, for example, are at 75 megawatts AC and they have had power purchase agreements that have been filed with the Commission over a number of years, and they're known to be in operation. I believe that the Lambert CPCN docket, that I think may be the only actual CPCN full proceeding that has come before this Commission. And I would note that in the entire record, my colleague has reviewed the entire record. I have not, but I'll take his word for it. In the entire record of the Lambert docket, which is extremely voluminous, there is in none of the testimony or filings is the DC capacity of that facility ever referred to. It shows up at most, one time in 5,000 pages somewhere on a site map or something like that. So that's really the only affirmative precedent that the Commission has. I think it's a matter of the lack of applications for known facilities and the practice. And also all of the other instances in which AC is used as the measure of capacity.
Thank you very much.
Thank you.
Further questions?
Commissioners, further questions for Mr. Snowden? Hearing none. Thank you, Mr. Snowden. We appreciate your time.
Thank you very much.
South Carolina Coastal Conservation League, Ms. Mixon.
Okay. Thank you, Chair Belser, and members of the Commission. My name is Kate Mixon, and I'm here representing the South Carolina Coastal Conservation League. First, a little bit about the interests of our clients in this proceeding. CCL is a nonprofit environmental organization whose mission is to protect the health of the natural resources of the South Carolina coastal plain and to ensure a high quality of life for all of the people who live in and love this special place. And to that end, CCL has worked for over 30 years to support environmentally sound land use and energy policy decisions throughout the state. These decisions are very complex, and so different state and local entities play different roles in different circumstances. And it is important to make sure that all of those involved in those important land use decisions, including siting generation resources, exercise their appropriate role under South Carolina law. The Siting Act sets out what that role is for the commission in siting generation facilities. And it determines when the commission is charged with deciding whether or where a facility is built, and when the legislature has decided to leave that decision to other state or local entities. The legal question in this case gets squarely to that issue. With respect to solar facilities, does the 75 megawatt capacity threshold for a major utility facility, which triggers review under the Siting Act, refer to 75 megawatts alternating current or 75 megawatts direct current? We, along with most parties to this case, think the answer to that question is very simple and clear. We have an AC grid, so the Siting Act applies where a generation facility exceeds 75 megawatts AC in capacity. That interpretation is consistent with how that act has been applied since its passage in 1971, and it provides a clear, cohesive line that can be applied in the same manner regardless of the type of generation resource. It's a yes or no question. Do you have the capability of producing more than 75 megawatts of power in AC or not? If you can, you're subject to all of the reviews that come along with the Siting Act, including the environmental reviews as required by the Act. And if you do not, then you're not subject to the Act and therefore fall beyond its jurisdiction. That's true if you're a 74 megawatt coal plant, not subject to the Act, or a 76 megawatt solar plant, subject to the Act. This isn't about whether solar is subject to the Siting Act. It's about when. And that should be based on the power that the plant can, not what it does, actually send to the grid represented in AC units. On the other hand, Dominion is asking this commission to find that solar facilities should be subject to the Siting Act if they exceed 75 megawatts DC capacity, arguing that solar facilities are somehow designed for or capable of operation at their DC rated capacity, even though the grid runs on AC power, and that DC power is unusable. And second, Dominion argues the Siting Act is at its core an environmental statute, and using a DC rating for solar facilities is more appropriate because it's more closely correlated with the acreage and therefore potential environmental impact of a solar facility. Dominion hasn't proposed any similar preliminary environmental review for any other type of generating resource. And that just doesn't make any sense when you look at the Siting Act. It only requires an environmental review after a facility qualifies using that 75 megawatt threshold, not before. As the only environmental organization that has intervened in this case, CCL strongly believes that Dominion's argument here has no legal or factual basis. And CCL is frankly concerned by the clear overreach and the unfair, uncertain application of the law that adopting Dominion's interpretation would cause. As I'll explain in more detail later, the 75 megawatt threshold, that determines the very scope of the Siting Act's jurisdiction. And it simply does not make any sense to use a different capacity metric for solar facilities compared with other resources when they are all producing the same type of power and that is expressed in AC units. Reading the Siting Act's definition of major utility facility to mean or to include facilities exceeding 75 megawatts AC is most consistent with the Act's plain language and harmonious with other provisions of the Act and its underlying legislative intent. I won't take the time to go through all of the different tenets of statutory construction. Again, I think that you've heard enough of that, and it's very consistent even across all the different parties' briefs. But I did wanted to highlight just one of those, which is that if a plain language reading of a statute leaves any doubt about legislative intent, the search for that intent can be gathered from a reading of the statute as a whole in light of the circumstances and conditions existing at the time of enactment. Also, in construing a statute, its words must be given their plain and ordinary meaning without resorting to subtle or forced construction to limit or expand the statute's operation. So with all of that in mind, I wanted to share some background, which we also have in our brief, that I hope will be helpful in kind of understanding the Siting Act's purpose and legislative intent and why that's most consistent with our proposed interpretation of the Act. As we, again, discussed in our brief, the South Carolina Siting Act is not unique. In the early to mid-'70s, over 20 states, including South Carolina, passed similar legislation or other initiatives addressing this very issue, the siting of utility power plants. It's clear the goal of these statutes was not to protect the environment at any cost, but instead to identify sufficiently major facilities based on their generation capacity, which may serve a broader public interest due to growing electricity demand, and then for those facilities to establish a consolidated approval process housed most commonly with state utility regulators like yourselves. That isn't to say that these statutes had no environmental protection purpose at all. They very clearly do, but the review required is best understood as a way to ensure that these significant facilities, one, are actually necessary, and two, that the environmental impacts from them are warranted. And so there are kind of three common elements in these statutes that demonstrate that and that are also seen in the South Carolina Siting Act. So first, the most common trend is that states required pre-construction review and approval for certain, again, major or large generating facilities. And importantly, nearly all of these laws define major facilities based on generation capacity expressed in megawatts. As Mr. Snowden mentioned earlier, then as in now, a facility's generation capacity was a poor metric for its environmental impact. As even just the generation resources that existed at the time, say coal and gas versus a nuclear plant, could have very different environmental impacts even at the same nameplate capacity rating. So it's significant that these legislatures used capacity and not environmental impact, or acreage for that matter, to determine the jurisdictional scope of these statutes. And again, we see exactly that in the South Carolina Siting Act, which defines a major utility facility as one exceeding 75 megawatts generation capacity and then requires a certificate from the commission before that facility's construction or operation. Second, for those facilities, again, that exceed that capacity threshold, and it did vary by state, the statutes typically required a demonstration of some sort of the need for the facility and some form of environmental review. Again, not to prevent all environmental harm, but rather to require a showing that the facility doesn't cause unnecessary harm to the environment. And again, this is exactly what we see in the Siting Act in Section 5833-160, which specifies the factors for the commission to consider in deciding whether to issue a certificate. Among those factors is whether the impacts of the facility upon the environment are justified, not whether they exist, whether they are justified relative to these other different factors that are also laid out. Third, these state siting laws commonly centralize or consolidate the review and approval process for these major facilities into one or sometimes a few agencies, including often allowing that agency to preempt other local or state permitting authorities to prevent delays and easier coordinate the siting of these facilities. The Siting Act likewise consolidates the approval authority or the ultimate decision about whether a facility can move forward with the commission. And while other relevant state agencies, including, for instance, DHEC and DNR, are made parties to those Siting Act proceedings, the Act is clear that the commission may refuse to apply any local law or local regulation if it finds that that law would be unreasonably restrictive as applied to that particular facility. So taken together, these elements all show the underlying purpose of the Siting Act and these other statutes is based on an assumption that facilities that can generate a sufficiently large amount of power may serve a broader public purpose that warrants, in some cases, preempting other permitting processes and therefore consolidating review into one entity. The regulatory oversight and environmental review required in these statutes is, again, best viewed as kind of a backstop to any impacts that may occur, to just ensure that the facility is actually necessary and, again, that the impacts are warranted. So kind of going into the specifics here, the plain language of the Siting Act, coupled with this historical context, makes it clear that the legislature intended this 75 megawatt threshold in the Siting Act to mean 75 megawatts AC for any type of generating resource, not just solar, but gas, nuclear, etc. So breaking this definition of major utility facility into its parts. First, as you've all seen, it refers to an electric generating plant and associated facilities. This clearly recognizes that power plants are made up of component parts. Each of these work together to convert energy at very basic level, so please don't ask me any specific engineering questions, to turn an unusable form of energy into a form that can actually be used on the grid, which, since the grid runs on alternating current, means AC capacity. For solar facilities, inverters are that kind of end essential component that converts an unusable form of energy, DC current, into the grid usable form in AC. For gas, coal, or nuclear plants, the turbines ultimately do that work. The energy that is initially stored in each of those fuels is converted to a usable form by first heating water that then creates steam that then turns a turbine that generates power. For any type of facility, and as energy is converted from one form into another, there are losses along the way because you can't convert energy from one form to another at 100% efficiency. And so the plain language in the statute reflects that and kind of shows that what matters is the facility as a whole and what that means in terms of the power that it is capable of producing in the form that is relevant to our AC grid, and that's the AC capacity rating. Designed for or capable of operation at, again, I won't belabor this point, but the grid runs on AC power. Without AC inverters, solar panels cannot send power to the grid, to our homes, and so would be functionally useless. They are designed for and intended to operate at their AC rating. And lastly, at a capacity exceeding 75 megawatts. Again, it's significant that the legislature used capacity as a threshold metric at all. Had they intended to base the Siting Act in its applicability on environmental impact, they could have used any number of environmental factors, but did not do so. Moreover, the Act has one number in it, 75 megawatts. That's evidence that the legislature intended a single threshold to be able to apply to all types of resources and therefore ensure a fair and consistent application of the law and an ability to compare on an apples-to-apples basis other generation alternatives, which is a requirement in another section of the Siting Act as well. Again, the only metric that allows that apples-to-apples comparison is looking at the AC capacity rating. And I do want to just be clear about our position on what that means, kind of in reference to your questions, Commissioner Williams, Commissioner Caston. If Dominion or anyone else built a 100 megawatt, coal plant that was capable of producing 100 megawatts AC, they could not say, oh, we're only going to actually send 70 megawatts to the grid. That facility clearly would be subject to the Siting Act. It would be capable of producing 100 megawatts AC. Our argument is that the 75 megawatt threshold essentially refers to the maximum amount of AC power that a facility can produce. For solar facilities, just like every other generation resource, again, that's its AC nameplate capacity rating. So viewed together, using the 75 megawatt AC capacity threshold, it's consistent with the statute's plain language. It harmonizes this threshold with all of the other provisions of the Siting Act. It's just consistent with the reality of operating the electrical grid. And it also fits within the historical understanding of what the legislature meant when it passed this law in 1971. And luckily, that interpretation and intent is just as relevant today as it was when it passed in 1971. Our grid still runs on AC power. Solar facilities still have an AC capacity rating. There's just no need to question that at this point. I also just want to be clear, this is, again, not about trying to evade review. There is nobody here trying to evade review in the same way that, we are not here questioning, what about a 74 megawatt coal plant? This is about interpreting the law in a way that makes sense and ensuring a clear, consistent threshold for when the Siting Act's review is required. And for that, the only metric that makes sense is to use 75 megawatts AC as that threshold. So I want to kind of contrast that with Dominion's proposed interpretation of the Act, which really muddies that otherwise very clear threshold. And it's inconsistent with the plain language of the statute. And in addition to that, Dominion's arguments for adopting this interpretation specifically for solar could equally be applied to any other type of facility as well. And so what that means is that at best, Dominion's interpretation would significantly complicate the question of when the Siting Act applies, not just for solar, but for all new generating facilities. Or at worst, Dominion is essentially asking that the law be applied inconsistently and unfairly to solar resources alone. And in terms of what's at stake in this case, I think this is important. And so I kind of want to break that down into those two situations. So for the commission to be able to apply the statute fairly to all resource types, it would be extremely complicated and would require determining for every resource whether there is another theoretical capacity metric that would be better correlated with that facility's environmental impact, and then basing the threshold on that, or determining whether it exceeded the 75 megawatt threshold based on that rather than what the facility could actually send to the grid. So for instance, let's say for a coal plant, the thermal capacity of the coal that it burns, and not maybe that should be used rather than its nameplate capacity rating to determine whether it would be subject to the Siting Act. After all, the amount of coal that facility burns, that's best correlated with its air emissions and thus its environmental impact. The only difference between that example and a solar facility is that there's not as commonly a number associated with what the thermal capacity is of the coal that it burns. But just the same as with the solar facility, ultimately that's not relevant, or it is relevant, but only later, to how much it actually produces. Because at the end of the day, what matters is what comes out of the piece of equipment that it converts that unusable energy into its usable form. And in addition to that, requiring that kind of review for every type of resource would have the commission evaluating the environmental impact of facilities on the front end to determine the threshold for when the Siting Act applies. That's entirely contrary to the Act's entire structure, which is very clear that first, there's a threshold for when the Act applies at all. And then, if and only if that threshold is met, are the requirements, including the environmental review, required? That happens after. The alternative to this very complicated review is unfair application of the law, where the commission would effectively be adding language into the statute to set two thresholds in the Act. If you're a gas, coal, or nuclear plant, it's 75 megawatts AC. But if you're a solar facility, it's 75 megawatts DC. In addition, kind of looking at the language of the statute itself, to adopt Dominion's interpretation, the commission would have to ignore the inclusion of associated facilities and instead consider a solar facility's inverters, again, the piece of equipment that's necessary to make the power from a solar panel usable, somehow separate from the electric generating plant. It would require finding that a solar generating facility is designed for, capable of operating at a capacity that's based on a form of grid unusable energy, DC, again, that just can't actually operate on the grid. And Dominion claims that using a DC capacity threshold for solar is needed because of a hypothetical factual scenario where a solar facility tried to, say, evade siting review by installing equipment and then upgrading or changing its inverter settings at a later date. I think this has been covered, but to be clear, this would be illegal. It is illegal to construct or operate any facility that exceeds 75 megawatts without undergoing Siting Act review. That includes changing a facility after its initial construction, and that again will be true for any type of generating resource, not just solar. Gas turbines can be upgraded, or a utility could replace them with larger units. Again, the issue that Dominion raises is not specific to solar facilities and in fact is already covered by the statute. If any type of facility planned to upgrade or did upgrade its equipment so that its capacity exceeded 75 megawatts AC, that would bring it under the purview of the Act, and it would have to obtain a Siting Act certificate in order to continue to operate, or it would have to fall within one of the exceptions to the Act. In sum, Dominion's interpretation would actually expand the scope of the Siting Act itself, in addition to resulting in inconsistent and unfair application of the law. It is the textbook definition of resorting to subtle or forced construction to limit or expand a statute's operation, and the Commission should squarely reject that interpretation. Instead, we respectfully request that the Commission issue an order declaring that the 75 megawatt threshold in the Siting Act refers to 75 megawatts AC capacity. Thank you.
Thank you, Ms. Mixon. Commissioners, questions?
Madam Chair,
Commissioner Irvin?
thank you. Good afternoon, Ms. Mixon. How are you today?
I'm doing well. How are you, Commissioner Irvin?
Fine. You made an important point that I just want to ask you to follow up on it, and that is really the only entity that has the legal authority to change state law would be the South Carolina General Assembly. Isn't that true?
Yes, Commissioner Irvin, we agree with that. Again, our client here is the South Carolina Coastal Conservation League. We are aware of and attuned to any potential land use impacts from solar facilities or any other type of generating facility. But the question here is just, does the Commission have jurisdiction over these facilities under the State Siting Act? And for all of the reasons that I explained, we think the threshold for when that applies is very clear. It means 75 megawatts AC. To the extent there are other policy considerations that may factor into whether some different thresholds should be applied, or any other limitations on where solar could be built. That's frankly beyond the commission's authority to decide here and is squarely within the purview of the legislature. I will say we've had some indication the legislature is aware of the land use impacts from solar facilities. There was proposed legislation in this past year, I think we mentioned this in our brief as well, that looked at solar facilities on farmland. And actually, when that bill passed out of committee, it didn't ultimately pass this year. It included language making clear that acreage was not relevant for the determination of Siting Act applicability. So to the extent that may be indicative that the legislature does have this on its radar, or at least some legislators do. Again, I think that's just kind of an issue for the legislature to decide, and it's something that, again, they have been thinking about.
And isn't it also true that the triggering mechanism for even getting to the Siting Act is whether or not a generating facility exceeds 75 AC. Is that correct?
Yes, that's correct.
And if they don't exceed 75 AC, the Siting Act has no applicability to that particular facility. True?
Yes.
And the General Assembly, in its discretion, chose 75 megawatt AC based on all the factors that the General Assembly would have to consider. And so the plain language of the statute really needs no interpretation, does it?
I do want to make sure that I'm at least recognizing the reason that we're here is that the statute does not expressly say AC. Again, for all of the reasons that me and all of the other parties here have explained, we think that that's really the only interpretation of that makes sense at all. But I mean, yes, that's correct. Other than saying that I think you're correct. There really is very little room for interpretation. That threshold is clear in the statute.
And in fact, a DC interpretation has never been applied by this commission or by our courts in South Carolina, has it?
That's correct.
So we would have to essentially break new ground and overturn all this legislative history and all the rulings that the PSC over some 50-odd years that they've been interpreting the Siting Act. We'd have to decide. We'd have to say, well, we really know what's best for South Carolina, regardless of what the General Assembly thinks. That's kind of where you'd have to go, isn't it?
Yes, and again, I think just to be clear, like the commission has not come out and said it is 75 megawatts AC, that applies. DC rating is irrelevant in terms of the threshold for Siting Act applicability, but through all of the decisions, again, starting with the very first, which Mr. Tarini was able to find, AC rating has been the metric that has been used. And again, solar facilities have an AC capacity rating. There are solar facilities that are currently operating that fall below 75 megawatts AC, but above 75 megawatts DC that did not require Siting Act review. And so I think, it is consistent with our understanding of, what the definition means in the statute and, all of the past practice to continue to understand it to mean AC capacity, and going beyond that, I think is outside of, would be going beyond what the language of the statute suggests.
And the practical effect of going beyond what the statute requires would simply add delay, additional cost, and another level of bureaucratic red tape that a facility would have to meet. Uh, and that, would you agree with that?
I would agree with that. I will say, our interest in this proceeding, we are not solar developers, and ultimately, I think, in our view, the impact on solar developers is irrelevant to this very clear, legal question, which is, is it 75 megawatts AC or DC that applies, for the Siting Act? But I think it is certainly true that it would add a significant amount of kind of cost and uncertainty, and to kind of what that means for statutory interpretation. As I mentioned, I think that interpreting this to mean DC in this instance would actually kind of throw open what that 75 megawatt capacity threshold could mean for all types of generating resources. And I think it's fairly clear that is not and cannot be what the legislature intended.
Thank you. Those are all the questions I have.
Thank you, Commissioner. Commissioners, further questions? Commissioner Justin Williams, I see your light. Do you have a question?
Yes, ma'am. Thank you, Thank you, Madam Chair. Good to see you, Attorney Mixon. I appreciate your use of analogies regarding thermal capacity and air quality and such when comparing a solar facility to a coal-fired plant. Do you know whether or not the solar array for, say, one of the units in question here, does it have the capability of producing more than the 74 and some change AC?
So my understanding is that it does not, unless they change the equipment that was installed at the facility. That is the maximum nameplate AC rating of the facility, and that is the maximum amount that could be sent to, again, the grid. And yeah, so
Okay.
yeah, I think that is the most that it could produce.
Thank you, ma'am. And do you think the General Assembly in 1971 contemplated solar generation facilities when passing the Siting Act?
So I'll admit I am not up to speed on exactly when solar facilities were first invented, or whether they did or could have known that was on the horizon. But ultimately, I again think that it's somewhat kind of irrelevant to this jurisdictional question. Again, I view the inverters of a solar facility very similar to a turbine itself. It is just the component of a solar facility that ultimately, converts energy so that it can be used for our electrical system. Without that component, that's just not the case. And that again was true in 1971 with respect to all of these other types of generation resources as well, and continues to hold today.
Thank you. Thank you, Madam Chair.
Thank you, Commissioner. Commissioner Caston.
Thank you, Madam Chair. So, did I hear you say that 100 megawatt coal, gas, nuclear, whatever facility, that only a facility like that is an AC generator,
Mhm.
even if they throttled, restricted what was put into the grid at 74.98 megawatts, did I understand you to say that those facilities would still fall under the Siting Act?
Yes, that is correct. And I think it's in the language of the statute is what is the facility as a whole designed for, capable of operation at. The question would be, could you put coal or gas or whatever it may be, burn that at this facility? And the turbines that are at that plant, are they capable of producing 100 megawatts AC power? If so, then it would be subject to the Siting Act. Yeah. And I guess the issue that I think was getting somewhat confused is it the amount that the facility actually sends to the grid, an amount that is going to change all of the time? Gas plants ramp up and they ramp down. Solar facilities, produce sometimes and they don't produce other times. But the Siting Act essentially sets kind of what is the facility's maximum AC output, at least in our view, AC output. That is the number that's relevant for Siting Act applicability.
Well, what I read is electric generating plant and associated facilities designed for or capable of operation at a capacity of more than 75 megawatts. And I've gone through this thing multiple times, and I think you've even said it too. There's nowhere in here where it says AC, DC, or anything. Is that correct?
That's correct. That it doesn't say AC or DC. If I may continue, designed for or capable of. A solar facility is not designed to produce an amount of power that exceeds what its AC inverters allow. It is designed for AC output, and therefore its inverters are an essential component of the facility, and the power that can come out of those inverters, like that is what they are designed for and capable of. Again, I think it's a very actually simple threshold question under the statute. Yeah.
I'm inclined to agree. If it's a 100 megawatt solar facility, the PV solar can produce 100 megawatts of electricity. And it only puts 74.98 in the grid. Would that come under the Siting Act?
So I want to be clear in that when I say, I guess the question would be, is that 100 megawatts, is that in AC units? If the facility is able to produce 100 megawatts of AC power, then yes, they would be subject to the Siting Act. If they were only sending, 75 megawatts, or 74 megawatts AC at any given moment, that wouldn't change the fact that they would be subject to the Siting Act in the first instance. I guess, when you say 100 megawatts of electricity, I think of maybe a better way to think of the way that solar panels work, and again, I am not an engineer, is to think of it in terms of energy. The sun produces energy, the panels collect that energy, that is then turned into DC current by the panels. That is another form of energy. That is, again, unusable by the grid. The AC inverters convert that to a usable form. In a very similar way that when you take, say, a bunch of natural gas, for example, doesn't have an AC capacity rating. Like if you have like a quantity of natural gas, it does not have an AC capacity rating. But that natural gas contains energy. It's in an unusable form at that point. You have to heat it up. It has to heat up something else. It has to create steam. It then turns a turbine. That eventually, or that is what creates the AC power output. That is what has been used to determine Siting Act applicability. Here, I just think you kind of have to think of the inverters as similar to a turbine in any other type of facility.
You're equating an inverter to a turbine. Is that correct?
Yeah, I think that's the analogy
Okay.
that
That's-
I'm making here, is that it is just as essential of a part of the electric generating plant as a turbine is to any other type of facility.
So the 100 megawatt electricity, you're saying must be AC. 100 megawatt solar facility, PV solar. It generates DC, direct current power, correct?
So I'm assuming that when you're saying 100 megawatts here, you
Correct.
mean it's DC capacity rating.
Right. But it can
yes.
generate 100 megawatts of DC, correct?
Yes, that's correct.
Okay.
In the same way, you could burn natural gas and put a pot over it and use it to cook food, but that's not what is ultimate. That is not what's used to determine Siting Act applicability. The question here is, again, what does this mean for the amount of electricity that can be put on the grid from a given facility? And for solar facilities, that is, again, their AC capacity rating.
When I asked this earlier, excuse me, I'm sorry, and I'll ask you too, can you show me in the Siting Act where it specifically talks about the electricity, the AC, where it talks about putting it into the grid?
So again, it doesn't specifically say into the grid. I hope that I kind of outlined all of the reasons when I was going through my argument about why that is the metric that makes sense to use when you are determining whether the Siting Act applies or not. I guess any other way of kind of understanding how you evaluate what the capacity of a generating unit, an electric generating plant is, it doesn't make any sense taken outside of the context of what power that it could actually produce that means something in terms of our electrical grid. Again, it's not the amount that they are exporting at any given time. The statute's clear. It's what they are designed for or capable of producing.
I'm glad you asked that because I know some of my previous stuff, we actually had generators, pumps, motors, different things, talking about nameplate, capacity, designed for, and capable of. And what they were designed for and capable of was what they were designed for and capable of. What can, under ideal conditions, they generate? What can they generate? Same thing with a pump. It was the pump, had a certain horsepower or whatever. What was it capable of pumping? Doesn't mean it's going to pump all that because we actually could throttle it. We had variable speed drives and such. So what I'm hearing is that designed for and capable of, and the capacity to produce only means AC, even for the generating facility. And earlier you had talked about what's fair. So if it's 100 megawatts gas or whatever, 100 megawatt solar, they're distinctly different just because one produces AC and one DC. Is that correct? Is that the distinguishing factor? Is that the only distinguishing factor?
So I'm trying to kind of think through how to answer that question. Just give me 1 second. But I guess I think that the only distinguishing factor is that solar panels have another rating that you can put and that that has a number attached to it. But they're not distinct in that their purpose is to produce AC power. That is the same as any other type of generating resource, the purpose of which is, again, to produce AC power. The only difference between solar and those other facilities is that, again, like there is a DC rating to start with. Again, nobody is kind of looking at the energy contained in the amount of coal that a coal plant burns and trying to use that to determine what the capacity of a coal plant is. What matters for that is the amount of AC power that it produces. Solar panels are indistinguishable, or solar facilities are indistinguishable in that way. They are designed for, and again, only capable of producing AC power, and therefore it is their AC nameplate capacity that is relevant. Using any other metric just doesn't comport with common sense or just the reality of, again, how the grid operates.
No more questions.
Thank you, Commissioner Caston. Commissioners? Commissioner Thomas?
Thank you. Sorry, I have to get this thing closed, and I hadn't done that today. I'm just reading the law. And again, we get back to that. Designed for or capable of operating at a capacity of more than 75 megawatts. And I'm starting to think about, okay, we have probably starting to have battery storage soon, if not already. And so if the unit is operating at pretty close to that 75 megawatts and it's putting that much on the grid, but it is also operating and putting DC charge into the batteries. So why would you not add together the AC and the DC to say, well, okay, well, this plant combination, the battery and the solar panels, it's designed for and capable of, when you add the two components together, because it's working at the same time, putting it on the grid and putting it in the battery, then how does this apply to that?
Commissioner Thomas, I was kind of hoping that nobody would ask me this exact question. I am not super familiar with exactly how you can configure like hybrid solar storage facilities. My very basic understanding is that a lot of the time, even the battery power ultimately would essentially go through the same inverters. And so the maximum output for the facility would still be limited to that kind of nameplate AC capacity rating. But I would otherwise kind of defer that question maybe to some of the fact witnesses that could speak more on what this would mean in the context of solar and storage.
All right, thank you.
Commissioners? Hearing none, thank you, Ms. Mixon. Appreciate your patience and your argument. Duke Energy Carolinas and Duke Energy Progress, Mr. Ellaby.
Suits you for me to be over here?
Wherever you're comfortable. I'll look over my left side for a while.
Madam Chair, members of the Commission, I'm Frank Ellerby, appearing for Duke Energy Carolinas, Duke Energy Progress. We were invited to respond to the ORS petition. As y'all know, we are only involved in docket 38, not docket 39. But we were invited by the Commission to respond to the ORS petition. And we did. We filed an answer to the petition. We've also filed some brief testimony from Russ Thatcher, who is a I'm happy to say, has expertise in solar project engineering and will be available to y'all to answer technical and engineering questions that are beyond my ability to respond to. I am very aware that I'm the fifth lawyer that y'all have heard from on this statutory construction question. Sixth lawyer. Sorry about that. And so what I'm going to try to not repeat and rehash arguments. I'm happy to try my best to answer questions that y'all have from Duke's perspective. And I'll try to touch on some of the things, obviously, that have been brought out today. We're here on a question of statutory construction. Y'all heard from everybody that the cardinal rule of statutory construction is, what is the intent of the General Assembly? What was the intent of the General Assembly when it adopted the statute? We are talking about language, the definition of major utility facility that was adopted in 1971 by the South Carolina General Assembly. The place to start is the starting point. And I hesitate to go back because it's been covered so much. But one thing that the trigger for your jurisdiction over to approve projects under the Siting Act is, it's not the panels, it's not the inverter, it's not the turbines, it's the major utility facility, the whole facility. And the facility is in our view, and this is in our testimony and in our brief, the energy, the generating plant, to use that term, is the panels plus the inverter. The associated facilities are the substation that is necessary to get that AC power to the grid. So it starts out as DC from the panels, the inverter converts it to AC, it gets to the substation and then to the grid as AC. And we believe that the only reasonable interpretation of that, because you're focusing on the major utility facility, not the component parts of the major utility facility, the trigger for your authority and your jurisdiction is, what does that facility put on the grid? I think one point that may have been touched on, but I'd like to emphasize, that another thing you look to when you're trying to figure out how to construe a statute is, how does it fit in with the intent, the overall intent of the whole statute? So we're looking at one definition, major utility facility, and we want to look to other provisions of the Act to see if that helps us, and I think it does. What the Commission is required to do by the 1971 Act is to make determinations for major utility facilities as to whether those facilities should be approved. And one of the things, and it's in 161C, is you have to make the determination of whether the environmental impact is justified considering the state of available technology and the nature and economics of the various alternatives. So if you think about that, and that was in the 1971 Act, you've got to get before you sufficient records so you understand what is going to be the environmental impact from the proposed project. And you have to weigh that against the benefit of this facility. And then you have to compare it to other alternatives. Only way you can do that, only way you can consider the benefit of the project that's being proposed and determine if the environmental impact is justified is to look at the AC output. The DC, the fact that there's a phase of this process where the power is DC and it's converted to AC is irrelevant. you look at the AC, what is that facility going to bring to the grid? And you have to look at AC. If you're going to compare to other types of generation, you have to make a comparison, as Ms. Mixon used my term that was in our brief, thank you, apples to apples. You got to make a comparison on AC basis. So all of the different types of generation should be looked at in terms of AC. That's how y'all, when you're determining if this impact is justified and if the project should be approved, you need to look at what does it bring to the grid. And in order to do that, you need to know what the AC output of the major utility facility is, not the component parts. So I think the statute itself, the statutory framework, very much supports that interpretation. I agree with what's been said today, that that's the way it has been interpreted over the years. There's not precedent on this specific issue because the industry has understood AC is that we look at these things in AC, and that's why until a couple of years ago when the issue arose in the Orangeburg case, the issue had not, there was an assumption that you looked at these projects in terms of the AC output. One other thing that hadn't been mentioned much, but I'll just mention it briefly. In 2019, there were pretty significant amendments, both to the IRP statute and to the Siting Act. And section 5833.110, subsection 8 was added that required a much more intensive comparison of different types of generation. The General Assembly doubling down on or giving y'all additional instructions to compare types of generation. The only way to do that is to look at them in the same terms, apples to apples, AC to AC. That's how you compare it. The manipulation issue, turning up the inverter, that is not a basis for this commission to interpret the statute differently from the way it's been interpreted. That is not a issue that is helpful to interpreting the statute. That is a issue of enforcement of the statute. This commission absolutely would retain jurisdiction to deal with those issues if they come up. There is no indication in the record so far that it has happened. We don't have an example of a bad actor manipulating its output of the inverter to put more electricity on the grid than is allowed without a Siting Act certificate. So that is not an issue. That evidence and that testimony, if there is testimony, and that argument isn't really relevant to the issue before you. We think the commission could deal with that issue if it does come up. In the same way, y'all dealt with a question of whether an apartment complex was a water and sewer utility recently within the last couple of weeks. I think some of y'all remember that. And you determined either you did have jurisdiction or you didn't have jurisdiction based on it. So that would be somebody can come to y'all and say, we think these people should have gotten a utility, should have gotten a Siting Act certificate. So it's not an issue that it's a problem. It's not something beyond the scope of your jurisdiction, and it really isn't relevant to the issue before you. Very briefly on the Broadview decision, the FCC decision, we have cited that in our brief. We don't suggest that it's binding on y'all. We do think it's persuasive that with under PURPA, FERC had a statutory limit, 80 megawatts. And the question was, how do we apply that to under PURPA? Is it DC or is it AC? And FERC focused on the output of the facility and used AC. And that's the extent of our reliance on that provision, on that finding. But we think it's helpful. We think it's persuasive. I don't want anybody to suggest that we think it's binding on the commission. One other point that I'll make, and I think it's important, and we've gotten into it. The commission under the Siting Act was given the authority to preempt certain local laws. And it's in two provisions, 5833-410, and also here it is. It's 5833-160-1E. And the commission can actually set aside under 161E, the commission can refuse to apply any local law or local regulation if it finds that, as applies to the proposed facility, the law is unreasonably restrictive. And that was a very, in my reading of the act is that was a really important thing. And Ms. Mixon and Mr. Snowden both suggested the same thing. The industry, I expect the industry needed something to help give this commission the authority to locate major utility facilities when there might be local opposition. So it gave y'all a big tool, an important, significant tool, which is to set aside the laws, local ordinances under certain circumstances if y'all make certain findings. That's a big deal. It's not something that y'all should lightly decide we're going to expand our jurisdiction by looking at the panels and how big a footprint the panels have. Those arguments might be attractive, and I acknowledge that there may be more environmental impact. That's something for the General Assembly to address. That's not for this commission to decide. We're going to start looking at not the facility as a whole and the output of the facility as a whole. We're going to look at what are the components and how much space are they going to take up on South Carolina farmland. That's beyond y'all's authority. Y'all have to apply the statute as it was written in 1971, which tells you to look at the facility and the output of the facility, and not go into the specific components that make up that facility. So we believe it's clear, and we believe the statute requires y'all to find that a major utility facility is 75 megawatts AC output to the grid. Thank you for your attention, and I'm happy to try to answer any questions.
Thank you, Mr. Elby. Commissioners? Commissioner Caston?
Thank you. Good afternoon, Mr. Elby. And you are the last, so let's go through this in a hurry.
I'm listening.
No, I know. In your brief, on page 7, where you have that diagram, you familiar with it?
I'm with you.
What generates the electricity in this diagram? What is the electricity generator in this diagram?
The generating plant, which is the term used in the statute, in the statutory definition, the generating plant is the combination of the solar panels and the inverter.
Okay, that's what this shows. The generating plant.
And our diagram says solar generating facility. At lunch, I talked to Mr. Thatcher, and he agreed with me that facility there is interchangeable with plant, and
I-
therefore I checked. I thought I might get that question, and so I'm on firm ground in saying that Duke's position is that the combination of those are the solar generating plant.
I've heard it interchangeable too. My question still being, all that said, it's part of the plant, just like the foundations, all that stuff's part of the plant. But what generates the electricity? What part of that plant generates the electricity?
Well, it's the combination. Now, Commissioner,
Okay.
you know, and I know that the DC output of those solar panels is more than 75 megawatts. We know that, the DC output. But that's, in our view, that is irrelevant to the question y'all have been asked to address. That is not what you should be looking at. If that helps you to get that concession from me.
Well, there's no, it helps me, and I know that's how you think I ought to look at it. Yes, thank you. And the comparison you talked about, the apples to apples, you talked about it just needs to be looking at AC. But I was thinking in terms of what the Siting Act, looking at, justifying the plan. So I was thinking, would that comparison also include things like capital cost, availability of materials, reliability, dispatchability of, in other words, if the commission was going to be doing that, if that's part of it, is it just looking at AC?
No, sir. Everything you mentioned is part of what's taken into account in doing the comparison. Absolutely.
Okay.
Yeah, I didn't mean to suggest that. I'm just saying that when you're looking at the output of the facility, you need to be, if we came in and said, oh, this is great, it's DC, the first thing y'all would ask is, well, wait a minute, we want to know what the AC out. We got to compare this with other generation. We want to know what the AC output is. We know about AC for every other type. So I think you need to get the common denominator, if you will, to go back to the extent of my math education.
And I think it's been mentioned about not the sovereignty of the county, but to the extent that, counties have, well, some have ordinances, some maybe don't. They're all different. We know that.
And some are considering them right now.
Right. But does Duke, for example, does Duke serve more than one county?
Yes, sir.
So considering, although the electricity or the plant may be in a county, one county, it can or could affect customers in multiple counties, correct?
It would be the way the Duke system operates. If they locate a plant that's integrated into their system, it would be part of the service to not only multiple counties, but also North Carolina and South Carolina. Customers in both states. Yes, sir.
Okay. I'm going to let you off, Mr. Allaby. I'd be getting into, well, I don't know if it'd be technical, but thank you very much. I appreciate your answers.
Thank you. Thank you, sir.
Commissioners? Commissioner
Madam Chair.
Thomas? Oh, sorry, Commissioner Urban, I'll be right with you. Thank you.
Thank you. So you were talking about the things that the commission can do now, such as the set aside of the local laws, and that we are supposed to determine that the interest of system economy and reliability are served. That's in that section 5833 161D. But we have that ability only if these things fall under the Citing Act, correct?
You make that determination under the Citing Act to approve the facility. You would, those, as the chair pointed out earlier today in an exchange with one of my colleagues, that at least for regulated utilities, when cost recovery happens, that's another opportunity for this commission to say, to look at very many of those very same questions.
Right, but that's a different thing. But anyway, so I guess my other thought too is that under PURPA, the utility, if it's a QF, then the utility will have to buy that power, whether it needs it, whether it serves system economy and reliability, even if we do say it's under the Citing Act and get to make that call. So the federal law is going to say you have to buy it. State law might say it's not in the best interest of the customers. So what happens then? We're kind of caught in the middle.
Well, the Citing Act, the fact that it is or isn't, whether it falls under PURPA doesn't affect your analysis under the Citing Act. And I'm not here to defend PURPA, but the idea under PURPA is that the utility is paying the avoided cost, and therefore it's not harmful. And I don't think PURPA has any direct bearing on the question before you, which is the construction of the South Carolina Citing Act and the definition of major utility facility.
All right. Thank you.
Yes, sir.
Thank you, Commissioner. Commissioner Irvin?
Thank you. Mr. Elby, good to see you. Thank you for being with us today.
Yes, sir.
Can you hear me okay?
I can.
Good. Would you agree that, well, let me back up just a minute. On a facility like the one that is involved in this proceeding today, the investor-owned utility, in this case Dominion, will enter a power purchase agreement with the facility, which sets a hard limit on the amount of megawatt. It's 75 or below. Is that right? They can't exceed that, otherwise they violate the PPA. Is that your understanding?
Mr. Chair, excuse me, Commissioner Irvin, Duke is not in that docket 39.
Yes.
So I do not know the details and the specifics of the arrangement between Pinegate, Catalina, and Dominion. So I really am not in a position to respond to that question about
Okay.
that.
I understand. Thank you. No further questions.
Thank you, Commissioner. Commissioners, anything further? Hearing none. Mr. Ellaby, thank you. Mr. Pelcher or Ms. Driggers?
Hello, this is Steve Pelcher. As we indicated in our March 3rd, 2023 answer, at this particular docket, we don't have a position on this issue of first impression, the AC/DC question. And as we reiterated in our March 3rd letter, we're not presenting any testimony in this matter. So we really have nothing to add this time.
Thank you, sir. Just didn't want you to feel left out.
Thank you.
With that, we will close the oral argument portion and take a quick break. We ought to be able to at least squeeze one witness in, or maybe two this afternoon. Mr. Torini?
Our first two witnesses, Mr. Hopkins and
Mr. Sechrist?
Sechrist, yeah, excuse me. it's
That's
longer.
all right.
They're a panel,
Okay.
so we would
Oh,
squeeze in 2 witnesses.
think we can get them in, get a lot done before, you think we'd finish with them before 5:30 or 6? I don't want to hamper you by swearing your witnesses in and you not being able to talk to them.
I don't think you're going to finish direct and cross with them.
Let's take a 10-minute break real quick. Let me.
Thank you.
Before you, we'll volunteer to put our witness up today if that's helpful.
That may be,
I mean, if y'all agree to taking witnesses out of order, that'll be fine. All right, that might answer my question. That's going to answer my question, Mr. Allaby, but let's still take a 10-minute break. They need time to reset in the back anyway.